Well, every state has some variation of a right to farm law designed to protect existing agricultural operations. However, they vary widely in each region, creating legal confusion for both farmers and their neighbors as well. Roger McEowen with the Washburn University School of Law joins us now with some guidance in today's Rural Money segment. Thanks for joining us, Roger. So what are the main types of right to farm laws, and talk about why they actually exist in the first place?
Yeah, good to be with you, Christina. These are prevalent in all the states across the country, and they exist for a good reason. And that good policy reason is that it's a real good idea to give protection to existing farming operations against nuisance litigation complaints that might be filed in court by a neighbor that happens to move in after the farm has been operating and is already there. And the idea is, well, that neighbor should have known that when you move next to a farming operation, it can be noisy during harvest, there can be dust, there can be lights at night, and if there's livestock, of course, there can be odors. So it's not fair for you to move in close to them while they're running that operation and sue them on a nuisance theory. That's the rationale. And the variation, you're right, the laws do differ depending on what state that you're in, but that's the basic reason that they exist, is to protect existing farming operations from nuisance lawsuits.
What happens if you decide that you want to stay in agriculture, but you're not exactly going to grow row crops, for example? Say an ag operation changes from growing corn to more of an industrialized hog enterprise, for example. Does a right to farm law still protect the ag operation in that situation?
Yeah, that's really where the rubber meets the road on these types of statutes, because agriculture has changed over the generations. You go back into the 60s and 70s, and you had a lot more prevalent and smaller operations that were more diversified. You had row crops, and you had livestock, you had chickens, and they were raised on small family farms. That has changed, and we see a more commercialized, industrialized type concentrated livestock operations today, in particularly in the Midwest and Iowa and so forth, where you have a lot of hog production, and the economics of that have driven it. But that raises a question: if a neighbor moves in nearby to an existing row crop operation, and then it changes to a multi-thousand head hog confinement operation, for example, that now has a lot of manure that is produced, and now it is so changed structurally that it really does present some touchy issues for neighbors. Does the right to farm law still protect that operation that has changed materially in its scope and in its size and in its the way that it actually functions, even though it's still producing an ag product?
Wow, it gets really tricky. Your job cannot be easy. I understand that the Indiana right to farm law has actually been in the courts recently. Can you give us an overview of that case and its status right now?
Yeah, that's exactly what I just mentioned, is exactly what's happened in an Indiana situation. The patriarch of the family retired, grew up on the farming premises in the early 1940s, still lives in the farm home, turned it over to a younger generation. The younger generation then vastly expanded the hog operation. Now Grandpa's got 8,000 head of confinement hogs within a quarter mile of his door. And it's presented issues for him. And unfortunately, you've got the senior generation of the family suing the younger generation of the family on a nuisance theory. They argued, the younger generation argued, well, we're still a farming operation. The Indiana right to farm law protects us. And the way that law is written, the court said, yeah, you can have any change in the operation, you're still protected. Now, not every state would protect that. The Kansas statute says it has to be a reasonable change, but that language is not in the Indiana statute. And now that case the request has been made of the U.S. Supreme Court to hear that case. And so that's the current status. And we won't know until later this fall or in the spring as to whether the U.S. Supreme Court will hear the case. And it's on a constitutional issue as to whether that law constitutes a taking of the senior generation's property rights.
It is so hard to see families get involved in some of these suits, but it happens. Yeah. It's just real life. Thank you so much. Yeah. Roger McEowen with the Washburn University School of Law. Always appreciate hearing from you.